Court is now in session. Be seated.
If it's okay, Judge, I'd like to have him start by being here at the podium with me so we can do a little demonstration for the court.
That's fine. Witnesses be reminded he's under.
I'm just trying.
Thank you, sir.
I asked you before the break if you could queue up the Home Depot digital scan that you created using the Pharaoh technology, correct?
Yes, sir, you did.
And specifically, I'm holding here State's Exhibit number 1, which is the vantage point essentially from the Home Depot video. You agree?
Yes, sir.
And one of the things I asked you to do was to maneuver our view through this 3D scan that's now being displayed for the court,
yes,
so that we can closely approximate State's Exhibit number 1, the picture of the vehicle with the defendant standing within the doorway, door open.
Yes, sir.
And is that what's now being displayed for the court?
Yes, sir.
Judge, I'm going to hand you the stack of photographs. State's Exhibit number 1 has got the top photo, and I'll let you have an opportunity to take a look at that and compare it to the demonstrative aid that's now being displayed before you so you can compare the vantage point. All right. Now that the judge has done that to my satisfaction, could you just back out a little bit and show where the camera can actually be seen, or at least the there it is. That's the actual camera that was captured by the scan, correct?
Right here, blue star, yes.
And that's how you were able to get to that actual vantage point that you just showed the court. By essentially placing yourself on the camera, then zooming in since we have augmented photos.
Yes.
Is that correct? All right. If you will, just move a little bit closer to the vehicle. Now, just pause there for a minute. I want to ask you about defendant's exhibit number. Where's you want?
Up there.
Yeah, defendant's exhibit number 1 is a bit misleading in that it starts off by showing that there's no roof on the top of the vehicle. Your scan actually, where you included the vehicle here, does indeed have a roof on it, does it not?
Yes, sir, it does.
Now, you had talked earlier about the ability to remove the roof so that you can see in the inside of the vehicle, correct?
Yes, sir, that's correct.
But to be clear, your scan, unlike defendant's number 1, actually does not have that box on it. You have to add that box to be able to remove the roof and see inside.
That's correct.
Why is it that you do the initial 3D scanning and imaging in an empty parking lot? To what benefit is that?
Sure, because otherwise what would happen if we scanned this, if this parking lot was full of vehicles, you would, in order to get sufficient coverage, you would need to do a significantly larger number of scans to fill the voids between the rows of parked cars. And it would be less visually appealing. We could scan additional vehicles or place 3D models of vehicles back into the scan if that was pertinent.
Right. But for this case, we asked you only to place the defendant's vehicle back in this since that's what we were focused on. Is that accurate?
Yes, sir, that's correct. If
we wanted to, we could take states 1 through 5 and actually put all of the vehicles back in there if need be.
That's correct.
Now, I want to ask you about this practice of placing vehicles. Is that one of the purposes of this technology?
Yes, sir.
And you were asked about giving testimony. Do you also do training around the country?
Yes, sir, I do.
And why don't you explain for the court what sort of training you do for other law enforcement agencies on the utilization of this 3D Pharaoh technology?
So my training involves instructing officers, whether it be crime scene investigators or crash reconstructionists, on how to use this particular software and also proper scanning techniques. And through that, I can, so for instance, inserting or combining scans like what we have done here is a very common practice, primarily for the crash reconstruction groups. It isn't unusual that they may scan the scene at a separate time from when they've actually scanned the vehicles. And then they'll merge those scans back together and place them whichever vantage or whatever particular position is important. Most times it's the point of impact, point of maximum engagement.
You've talked about two of the common ways that you could do that. One would be to review any video footage if it exists to see whether the vehicle was there, or have law enforcement do the same and then pass that information on to you, correct?
Yes, that's correct.
Of course, the second way you could do that is if law enforcement made any markings in a particular location, such
Judge,
as...
I'm going to object to the form of questions. I mean, he's been leading this whole time.
Yes, sir, witness.
I'll try not to lead. Well, how is it helpful to have paint markings?
Paint markings on a location give you, it's effectively whoever marks the scene, there's a certain pattern that they follow, so they'll mark the outlines of the tire locations, and then that allows us to place the vehicle back within those same tire mark locations.
The court has seen a couple of different scans here. One is the 3D scan, and one is the more photographic version of the scan. Can you explain why you have two when you do the scans?
Yes. So the first, what we're looking at here is the actual 3D captured data points. So there are millions of data points here being displayed. The more photorealistic example that you see, that's what you're seeing is the actual color camera captured image and the combining of those individual images into a single panorama.
But you're allowed to access both once you make the scans?
Yes, sir, that's correct.
And just as we saw with the iPad that was displayed for the court, which was the panoramic photo, that's actually a series of photographs that are taken in a panoramic style, correct?
Yes, sir, that's correct.
But photographic evidence?
Yes, sir.
Now, the figure that you added here, can you adjust the height on that?
Yes, you could do an overall scale on the character if you wished. Typically, what we do with this is we create it and pose it in a different software package, one called 3D Studio Max. And so then, so we orient the character, and then we will, actually import it into this scene, and then position it accordingly.
Because defense counsel has introduced defense exhibit number 1, why don't you just demonstrate to the court how you can do that version if you wanted to, as opposed to what we're seeing here?
That, I mean, talking about hiding the roof?
Correct. And what's the purpose of hiding the roof? What does that allow us to see that you otherwise could not on your version that was previously displayed?
It just shows the spatial relationship between the objects in the interior. So
it demonstrates the interior as well as the exterior?
Yes, and then also you see we have our measurement objects in here, and then these targets were used for tracking or registration of the handheld scans.
Since you brought up the handheld scans, does the position of the scanner change or alter the data points, or just the vantage point?
It really only changes the vantage point. There are some physical limitations of getting too close to an object, but for the most part, changing the vantage point actually enhances the scan, being able to see the points from a different location. If you only did a single scan from a single location, you would end up with voids behind any object that blocked the laser.
For instance, if I were a scanner and you turned me on and I did a 360 scan, would that scan show what's just adjacent to the podium?
There would be a complete void behind the podium.
In other words, in order to have that area scanned as well, you would need at least 2 scan points to make sure that we cover both sides of the podium?
Or more, yes, sir.
You said or more. If I wanted to get fully this side, probably
yes,
at least a 3rd scanner here to catch all sides of the podium?
Yes, sir, that'd be correct.
That's why, is that why it took so long to do the scans of the parking lot?
Yes, sir.
Now, the purpose of the box here, is that so you could show spatial proximity and demonstrate the location of items within the vehicle if you wanted to see that?
Yes, sir.
Defense counsel talked about 2D versus 3D. Which one shows depth?
3D, obviously.
Fisheye versus panoramic. Describe the difference between those two terms.
Fisheye is typically a static or a dedicated lens. You take a single, you'll take a fisheye capture, and it is actually a distorted image captured by the camera. The difference between that and what's captured here, there is no distortion on the lens other than some inherent barrel distortion, things like that. But they actually vignette most of the distortion out, so then they combine the images together into a single panorama.
Could you please close this one out and bring up the second scan that we talked about? I want to talk about the final resting place of defendant's vehicle at Matteo's. Very briefly. What's now being displayed for the court? Is this the Little Matteo's area that you talked about? Uncle Matteo's, excuse me. I always say Little and it's Uncle.
Yes, so this is the area that we scanned behind Uncle Matteo's.
Now, for this particular version, you have a box obviously on top of the car so that you've removed the top. Is that correct?
Yes, sir, that's correct.
Can you remove that box? What I specifically want to focus on are the markings on the ground such that you were able to demonstrate where the vehicle was, replacing that there. Can you actually see the scanned marks on the ground by the tires?
Yes, sir.
And just dial down to those, do the passenger rear wheel, if you will, show, all right, that marking is. Can you go to the other side of the vehicle for me? And there are the other two markings on the driver's side of the vehicle such that you were able to place the vehicle back into that scene. Is that correct?
Yes, sir, that's correct.
All right, you can dial back out of that if you don't mind. And why don't you take your seat? I'm going to ask you a few questions. I'm almost done here with about the scanned interior of the vehicle. All right, first question is, do you agree that the Pharaoh scanner is a machine, correct?
Yes, sir, that's correct.
And if it's functioning properly and on the Pharaoh machine, you said being C, would you expect it to be asked to do a 360 scan? It's going to do a 360 scan if it functions properly?
Yes, sir, that's correct.
That would also include getting the headrest?
Yes, sir, that's correct.
By the way, if one were to turn just ever so slightly, would you agree from that vantage point you would be able to see the back of the headrest?
Yes, sir.
I want to ask you about some of Mr. Kilgore's questions about the placement. There was a suggestion that scanner was placed by the steering wheel. Is that where you placed the Pharaoh scanner, on the inside of the vehicle?
No, sir. Actually,
okay. Can you explain in more detail where you specifically placed that Pharaoh scanner?
We placed it on the driver's seat and then elevated the scanner head, they call it, the scanner head position, to an elevation consistent with my eye height.
Now, I'm going to ask you about that. If you did it at a different level, is it going to change the accuracy of what's captured?
No, sir.
What does change?
Just changes the perspective of the capture.
If, for example, we use Mr. Kilgore's height versus the defendant's height, would you expect that it's going to still capture accurately the images, just a different vantage point?
Yes, sir, that's correct.
And in this particular case, you were able to do that. You have your iPad with you? Yes, please. All right, just so we can show the court, this is the scan of the interior of the vehicle, is it not?
Yes, sir.
There. This is a side view, and then to be fair to the defense, that's the headrest that the scanner's in front of. Is that correct?
Yes, sir.
Okay. And this simply captures the interior of the vehicle, correct?
Yes, sir.
And the items that are therein.
Correct.
Does that scan help to demonstrate spatial proximity of items inside the vehicle, including the car seat?
Yes, sir.
Does it help to demonstrate distances of certain items from each other within the interior of that vehicle?
Yes, sir.
And is that the purpose of doing the 3D scan of the interior of the vehicle?
Yes, sir.
I think that's it, Judge.
Just a couple things to follow up on. First thing I want to clear up on on cross, you identified Defendant's Exhibit 1
Yes, sir.
as an image which was a still taken from the scan which you created, right?
It looks like it's pulled from the video, I believe.
Okay. So this image is depicting something that you created.
Yes, sir.
Okay. Mr. Evans told the court that D1 was misleading. So what I want to ask you is, if you created this and it is part of your scan, how is it misleading?
Judge, I'm going to object to the characterization of my question of Mr. Dustin. I was suggesting that the manner in which it was given to the court was misleading, not that the scan itself is misleading. There's clearly a distinction between the two.
If the court will recall, it really wasn't a question. What Mr. Evans said was, well, this is a big one's a little misleading, so let me ask you. So I agree it wasn't exactly his question, but I think it's a very fair question for us to ask. If the state is asserting that their evidence, which I have marked, is misleading, I think we need to hear how and why.
No.
How is it misleading?
Well, it's misleading in that your question was, does this depict the defendant's vehicle? And my response was, it depicts the defendant's vehicle if the clipping box is in position. If the clipping box is removed, then you don't get that image, or just turned off as far as being enabled.
Okay. Do you agree this image comes from your creation?
Yes, sir, that's correct.
Okay. When you talked a little bit about the scanning the interior in a handheld scanner.
Yes, sir.
And if I understand correctly, what you did was you sat in the driver's seat of the vehicle. And did you then hold a scanner at your eye level?
No, sir. I believe you misunderstood me. When you do the hand scanner is like think of a painting like with a Wagner power painter. It's a pretty close analogy in that you are moving it around the object that you're trying to paint. Only in this scenario, you're capturing data. So it isn't as if I sat there and held it at a certain height, at my eye height, and turned around. I actually did it. Some scans were done from the exterior of the vehicle, leaning in to capture the data. So it was not from a single vantage point.
Okay. I've got a follow-up to that, but first I want to clarify exactly how you did it. Is it not true that you sat in the vehicle while Detective Stoddard looked at your approximate eye height and you placed the scanner as closely to represent that height as you could? And then Detective Stoddard gave you a thumbs up.
We're talking about two different devices. One is a fixed or what's called a terrestrial scanner, and the other is a handheld device. So we're talking about two different. So when Detective Stoddard gave me the thumbs up, as far as being the eye level being correct, that was the terrestrial scanner. That was the X330 scanner.
Okay. And what does the terrestrial scanner do? Why are you sitting in there looking for him to give you an approximation of some eye level?
So we could do a scan from the driver's position.
Okay. And so the purpose of that then is to demonstrate what the driver can see sitting at that placement.
I think you can demonstrate what is visible from a line of sight. I'm not pretending to say what the defendant saw or what he didn't see.
Okay. And the line of sight would, if that's what you're attempting to depict or show, you would agree that definitely would change depending on the height of the individual, the height of the individual's eyes sitting in the driver's seat.
Yes, sir, that's correct.
And in order to do this scanner, you just sat in the seat and you held it up.
No, sir. No, sir, it's not correct.
Okay.
So let me back up. So the way that we did this was I sat in the seat. Detective Stoddard viewed me sitting in the seat, got an approximation of my eye height level. I exited the seat, placed the scanner in the position, adjusted the position, so the center or the focal point of the device was approximately at the same elevation as what my eye height would be.
Okay. And if I understand correctly, then Detective Stoddard just kind of eyeballed it up from outside the car.
He was outside the car. How he arrived at his determination is unknown to me.
All right. Well, you were there. And so
Yes, sir.
let me ask you, did he have a ruler or any sort of measuring device at all to get that where
He stayed in the same position. He stayed in the same position while I exited the vehicle, placed the scanner at the correct height, and then through several adjustments, finally I got it to where he was satisfied, and then he said that was good.
Okay. And you would agree then that is all of the information you used to set the height of that scanner?
That's correct.
And you said there was a second type of scanner.
Yes, sir.
Was there, in fact, one that was handheld inside the vehicle?
Yes, sir. You're symbolizing as if it was like a video camera. It isn't anything like that.
Okay.
It's think of a three-pronged device with a handle on it, approximately, we'll just say 12 inches by 12 inches, and about 6 inches in depth. So that's the difference between the hand scanner and then the terrestrial-based scanner.
Okay. So the second scanner we're talking about, this is the scanner that you're telling us it's better if you've got all different kinds of vantage points, right?
It allows you to capture whatever surfaces you want from a variety of perspectives because it's handheld and it's mobile, and you also have visual feedback. So you're connected to a Windows tablet and you're watching it propagate as you're capturing it. So if there's a void that needs to be captured that you haven't done so yet, then you can position the scanner to an appropriate location to be able to fill in those data spots.
So this particular type of scan doesn't have anything to do with determining line of sight then?
It's line of sight only in the manner of capture for the device.
Okay.
Okay. So think about this. So if I were to try to scan a table from beginning to end, I would move the device from end to end. So I'm changing the orientation or the location of the scanner in order to capture all of the data points.
All right. Is it fair to say that scan is simply to map the interior?
Yes, sir. That's correct.
Okay. And then the first scan we talked about, the one where we were trying to get the right eye height, Detective Stoddard was trying to get you to the right eye height. But that scan is the one that deals more with line of sight, correct?
They both deal with line of sight. So I want to be careful here. On virtually any scanning device is going to be line of sight. I don't mean to argue semantics. I'm trying to be very careful with my answers.
Okay. Well, when you tell us something like, well, we want to get as many vantage points as possible, well, I mean, a driver may only have one line of sight because he's got one vantage point, not over here or down here or hanging out the window over here, but where he's sitting, right?
Yes, sir. We could have acquired more.
And the information that you're basing your creation on is coming from Stoddard.
Yes, sir.
Okay. We took a look at the image from the parking lot in Matios.
Yes, sir.
And we saw on the scan the creation that there's no back window.
Correct.
In that car. And you agree that with no back window in there, we don't have variables such as glare or dirty window or anything like that, shadows that may impact what a person could actually see if they were there on the scene.
I think that's a fair statement, yes, sir.
All right. Now we've messed with this a little bit, and it certainly seems to me no matter what we do, no matter where we go on that image with the top off and the windows out from Matios, I mean, you can pretty much see that car seat from anywhere, no matter where you are, right?
I don't think that's true, but
Okay.
if you went behind the wall of the Matios, you wouldn't see it.
Right.
If you were positioned over the B pillar, you would not see it. If you were low, you would not see it.
And those angles are available on your scan.
Sure. Yes, sir.
Can you think of any other variables as to someone's vision into that car? Any other variables that we haven't touched on, such as shadows or glare or dirty windows? Anything else?
No, sir. I'm not qualified to. I'm not an expert on what the eye can see.
Okay. Judge, I think that may be all I have. What's that? How many separate videos did you create? First, how many separate animated creations did you make?
Well, we need to differentiate between animations and videos. Animation typically depicts some sort of movement of an object, whether it be a vehicle or whether it be a character or some other object. So that, as far as I understand, well, I did 4. There were a total of 4. Two of them are the same. One was just done at a lower, what's called a lower bit rate, so that it would play on an average computer. That depicted a vehicle moving over a Google Earth image. But from what I gathered, that video is not, that is actually an animation. That animation is not going to be used. The other 2 videos that were created were what we call fly-through videos, and those were done effectively. You place a camera on a path and you move it through the scene, and then you render the video.
So is that 4 total or 6 total?
Well, technically 3. One is a duplicate at a lower resolution.
Okay.
I believe.
All right. Since we've got you on the stand, can you show us the 3 videos then? In particular, the one, not the video, the creation, the animated creation from Matios and from the Home Depot. Can you
object to that? You specified there are no animations regarding that. So it's not possible to do that. The only animation we create that we're not playing.
right, can you show us the scans that you created?
Did you want to see the fly-through video, sir?
Where it shows the car driving looks like a Monopoly board?
Judge, we've already discussed that we're not using that as part of the dialogue. I don't see what the relevant purpose is of playing something that they rejected to and we said we're not going to play.
Well, I'm not asking him to play that. I was answering his question, clarifying if that's what he's talking about. The answer is no, I don't want to see that. I want to see what I told you, what I asked you about.
Almost the same objection.
What was at Matteo's and what was at Home Depot? So can you show us those, please?
I would need to come to that computer and connect up the hard drive.
Okay, thank you.
Can I clarify? Mr. Kilgore, are you asking to play the fly-through?
I'm asking to play everything that was taken from Home Depot, everything that was taken from Matteo's.
So I'm confused. Do you want to see this, the laser scan, or do you want to see the video?
Yes, the fly-throughs.
Okay.
The hard drive is... you see, Mr. President, these fly-throughs are actually on the computer. We have Mr. President, it may be loaded on the computer, too.
I think we may have the fly-throughs right here. I got some of those right there just in case.
Which parking lot is this, sir?
This is the Home Depot parking lot.
Thank you. All right, can you stop it right there, please? All right, Mr. Dustin, you agreed that in the image that we're looking at, that the roof and windows are absolutely removed.
The roof is hidden, yes, sir.
Okay. And by hidden, meaning we can't see it. The image looks like a convertible, right?
I wouldn't call it a convertible.
Just an image without a car without a roof or windows.
Yes, sir.
Okay. Go ahead. Thank you.
But I might add that back here, the roof is present. And then all we did was fade to the view with the roof hidden, again, just to show the spatial orientation.
All right, stop right there, please. And what we see where you stop there is the cartoon figure is standing right at the driver's side door, facing perpendicular with the car, and has both hands, both arms inside the vehicle. Is that right?
Well, it's not a cartoon character. It's more of a photorealistic model. But yes, the model is positioned with the arms extended into the vehicle compartment.
Okay. And that information to create this is what you got from Detective Stockton?
Yes, sir.
Okay. Go ahead. Thank you.
Did you want to see the next one?
Please. tell from this image how far from the vehicle, what distance this demonstrates to the viewer?
No, sir.
Okay. Do you know from more than 50 feet away?
No, sir.
Or more than 10 feet away?
I would guess more than 10 feet, but other than that,
Sure. Well, can you tell us at what height off of the ground this image is
no, sir.
portraying?
No, sir.
Okay. Can you tell if it's
not from the video.
Sorry.
Not from the video.
Can you tell if the angle is from more than 30 or 40 feet in the air?
No.
Can't tell.
No, sir. Not from the video.
All right. You would agree in this image that there is no rear window in that vehicle, correct?
That's correct.
Okay. And even however far off the ground we are, at whatever distance, you can already see the car seat from this angle, right?
You can see something red inside the vehicle, whether it's a car seat or not, I don't know.
Okay. How are we going to ever know at what distance this view is and what height off the ground this view is?
We can go back into the 3D software. This point is saved. You could view it from that point. You could place an object. You could actually calculate that.
Okay. That data is not included in your report. Is that something that you can get for us?
You have the files. You have every file. You've got this. You've got the file that I created the video from.
Okay. So as we're here today in court, you cannot tell us at what distance this view is from.
Can you? I mean, you don't know. You don't. There's no readout. There's no XYZ coordinates for the location of the camera. Not listed here.
Or how far off the ground this view would be from.
If I opened up the software, I could go back to this font. There is a way to calculate it. Yes, sir. Looking at the video, there's no way.
Okay.
Anything would be an estimate.
All right. Thank you. Go ahead. You would agree that the roof has just disappeared?
It is being hidden, yes, sir.
Okay, stop it right there, please. All right, so it's essentially the same question. Looking at it right now, you can't tell if this view was from more than 50 feet away, can you?
No, sir. Can you?
Okay. And you can't tell how high off the ground, how many feet off the ground this view is from, can you?
Not from the video, no, sir.
Okay. But if it was 50 feet away and 50 feet up in the air, from this view, you can clearly see a car seat in there, right?
That's correct.
Okay, thank you. Go ahead. Thank you very much. I don't have any further questions.
Very, very briefly, there's a difference between a fly. Would you agree there's a difference between a fly-through and actual 3D scans themselves?
Well, technically a 3D scan is a collection of data points. A fly-through allows you to visualize those 3D data points.
Right. So the fly-through essentially shows what the capabilities of the 3D software are for a particular scene. Is that accurate?
Yes, sir, that's correct.
But the actual demonstrative aid itself is going to be the 3D scan of these three locations that we talked about.
Yes, sir.
Thank you.
Thank you.
I have anything further, Judge?
Do you have any evidence on this point?
We'll call a statement about it.
Well, that's not your evidence, that's just your cross.
Yes, ma'am.
And that's fine.
Yes, ma'am.
Goddard, you had indicated that there were measurements taken at the scene, that being the scene at Matteo's. Is that correct?
That is correct.
All right. And I think it was Grimstead was kind of like the primary crime scene detective that was there that day.
That is correct.
All right. Now from this...
Oh, wait, no. Shumpert. Shumpert was the primary at the crime scene that day.
Okay.
Brad Shumpert.
And do you recall at this time which detective took most of the measurements, whether it was Shumpert or Grimstead?
It should have been Shumpert. I wasn't on scene when they were doing measurements.
Okay. And there were measurements taken of the outside of the vehicle as well as inside dimensions, including the placement of the car seat.
Correct.
Right. And there were also photographs taken of the vehicle and the scene around the vehicle there at Matteo's with a camera, still images made by your detectives.
That is correct.
Okay. And we got a lot of photos. Do you have any recollection of how many exterior and interior photos were taken there on the scene at Matteo's?
No, sir.
Right. And you would agree with me that there were, as far as the exterior of the vehicle goes, there were pictures taken from all sides and all kinds of different angles.
Correct.
Okay. And that's essentially the same thing as the interior as well. There's all sort of different angles and views and whatnot of the pictures taken from inside the vehicle while it was still there at Matteo's.
No.
Okay.
When it was there at Matteo's, they did take a lot of photos.
Mm-hmm.
The vehicle was then removed and taken to, and I don't think Shumpert even went in the vehicle at Matteo's. We pretty much just shut it up and would have been transported. Search warrant was issued. And then back at the CSI shed at Copley's headquarters is when the search warrant was served by Detective Grimstead. And then more photos and the measurements of the car seat and all that would have occurred in more depth. I don't know, I can't remember exactly what Shumpert did on scene, but that's our normal, what we would do.
Okay.
Let's wait till it got to the CSI shed.
Right. And that squares with what we've got, what we've looked at. We've got some photographs taken there at Matteo's.
Correct.
And then additional photographs, and particularly a lot of interior photographs taken there in the shed. Right.
Yes.
Without having an exact number, you would agree that it was dozens or scores, if not maybe even over 100 photographs taken.
I would say easily over 100.
Okay. Including different viewpoints with inside the vehicle. In other words, we've got photographs taken from the driver's seat, from the passenger side, from the back seat, and all different kind of angles.
That's correct.
Now, do you recall when, one more thing before we move on, do you recall who would have been the CSI detective who took any video of the exterior or interior of the vehicle?
It would have been done on scene. Would have been the first thing done on scene. So I would say CSI Shumpert.
Okay. And that essentially is depicting some of the same thing that the still images are depicting, that being the exterior of the vehicle, the interior from different sides of the car, from different sort of vantage points.
Yes, sir.
Okay. All right. And just to make the record complete, you certainly agree that the vehicle in question was not a convertible.
I agree.
I mean, it actually had a roof.
Yes, sir.
Okay. And it had windows.
Yes, it did.
Okay. So, I mean, to the extent that these images and some of that video that we saw demonstrates otherwise, you would agree that this is not an accurate portrayal of what the actual vehicle looked like, at least from the outside.
No, it is an accurate portrayal. All it is like, Mr. Dustin said, it's just hidden. Right. And to get to that point, you have to go through the actual hood. So you start off from afar, And then you work your way in. So to get to that picture, you would have seen it had a hood. You would have seen it had windows and tent and everything else. It's a progression.
Do you agree that when we take all the windows out and the top off, it's pretty much makes it a lot easier to see anything inside the vehicle, right?
Yes.
Excuse me. Did you specifically ask Mr. Dustin if he had the capability of to create such images, taking away the top of the car or the windows?
Mr. Dustin showed me some of his earlier material, and part of it was fly-throughs and such as that. And we asked if we could do that with this also as part of the 3D. As you start from afar and you work your way in and kind of get involved in the scene.
And you've been in here during the time that he testified, so you heard the last few questions I was asking him about. So I'll ask you the same thing. Do you know, when we're looking at those videos, do you know at what distance from the vehicle?
No, sir.
Those images are from? Don't know. Do you know what height off the ground they're from?
No, sir.
Okay. And you would agree it sort of looks like, well, they're called a flyover, and you would agree it sort of looks like maybe if you were in a helicopter coming in and you're sort of descending on the vehicle and then flying around.
Yes.
If you've got a better analogy, I'm open to it. All right, so we heard from Mr. Dustin that he got a lot of the information from you in creating these images, and in particular, we talked about the location of the vehicle in the Home Depot parking lot.
You're correct.
You agree that we've got an actual surveillance video of the vehicle in the parking lot in the morning, in the afternoon, during the middle of the day? We've got actual surveillance video of that, right?
We do.
Okay. And you did not share those with him?
I did not.
All right. And have some still photographs been taken of the vehicle as it sat in the parking lot at Home Depot?
No.
Okay. Where did you get those images from?
They came from the video.
All right. Just cut from the video.
Yes, sir.
All right. Now, he apparently saw those for the first time this morning. Do you remember what photograph that you showed him?
He was shown, I'm sorry, several photographs. Every scene we went to, I had crime scene photos, and I had the still photos from the video. He was not allowed to take them. He was not allowed to include them in his report, but he was shown the reports, or shown the pictures.
Okay. All right. So, and have you reviewed his report?
I can't remember. I'm sorry. No.
Okay. Well, if he testified that he had only one photograph of the parking lot at Home Depot, you're saying you disagree with that he had more than one?
I don't disagree. That's not what I said. He was shown pictures. Right. He had one. He had one photo. And it's not our practice, especially as a detective or with a cop and police, to put evidence out there. The less evidence out there, the better. And in this case, we didn't want anybody to get a hold of it. We didn't want the media to get a hold of it. So it was maintained for me. And one photo was shown. It was the vehicle all the way in the back. Was given to him, but he was shown multiple pictures.
Do you agree with his assessment that the date in which the scans were done was July the 4th?
There were several dates. But one of the dates was July 4th.
All right, I'm talking specifically about the parking lot at Home Depot.
There was 2 days that the Home Depot was scanned.
And what dates do you have for that?
I got the 2nd of July and the 4th of July.
All right. And we heard from Mr. Dustin that he got the information of sort of the location of where the vehicle would be in the parking lot. He got that information from you.
That's correct.
All right. So if I understand, he creates an image or a scan of the parking lot, then comes back afterwards and places the vehicle in the creation.
Correct.
And you just simply showed him whereabouts the car should be.
Correct.
And where did you get the exact measurements of where to place the vehicle?
Well, the Home Depot was from the surveillance video.
Okay.
And it's an approximation.
Okay. And you wouldn't have any idea sort of what your margin of error would be. You don't know if you could be a foot off or 3 feet off, or do you know?
It was in between the lines.
Okay.
So if we would measure the parking space, and we could probably work it out, but we'll say a foot.
And just again, for the record, to be clear, the scans that we saw are a single vehicle in a parking lot. But in fact, that was not what the scene looked like on that day in June in 2014. There were lots of cars in the parking lot.
Yes, sir.
Okay. All right. Then discussed the fact that as far as putting the figure in the image standing there in the car, next to the car, you gave him the information on where to put the figure.
Yes, sir.
When did you give him that information?
He was shown the pictures, and then he would ask, well, how close was he? Where was he approximately? And I'm like, well, he's in the door frame, with the arm inside of the vehicle. And then he did it. We met up afterwards. He showed me his finished product, and it was a close approximation.
Okay. So you agree it's not exact?
No.
And I was paying particular attention on your direct, and you said the same thing a minute ago. Arm singular. You told him that the individual put an arm in the vehicle.
From the video, you can't tell if it's arm or arms. I don't recall exactly what I told him. But if you look at the video, you can't tell 100% if it was an arm or arms that entered the vehicle. At least one arm enters the vehicle, and a package is thrown inside.
Okay. At least one arm.
At least one.
Sure. And you agree, if it's at least one, then that means that it's possible that it was only one.
True.
Okay. But the image that you okayed, and working with David Dustin, the image that you okayed in the scan, it has both arms in.
Yes, it does.
And you would agree that's just a guess.
It's an approximation.
Okay. Well, one arm is different than two arms. You're telling us you don't know whether it was one or two. But your position is that it was two.
My position is it could have been two.
Okay. And so if it could have been one, you would agree that the image is wrong.
No. I would say that you can't say if it was one or two. And we don't know. Only one person knows.
Okay. Why is it then that in creating this digital imagery, why is it that it's depicted with two instead of one?
That's what Mr. Dustin decided to put in was two.
So your testimony is then that was a call that he made on his own. He went with two arms in just on his own.
My testimony, I do not recall telling him that. I don't recall the conversation. I don't recall whether I said, hey, it could have been one arm, two arms. We're not sure. I don't specifically remember telling him two arms, but it could be true. It could be right.
Well, again, you've been in here while he was testifying. So
I did.
His testimony was that the information that he used to create the image, to create what we're seeing there, he got it from you.
Correct.
Okay. So would you agree it's fair to assume that you told him it was 2 arms inside the car?
No.
Okay. After the image was after the digital creation was completed, and you had a chance to take a look at it, and you saw that it demonstrated an individual with 2 arms inside the vehicle, did you contact David Dustin and say, "Hey, this is not accurate. We don't have information that it's actually 2 arms in the vehicle. That this is not accurate."
Once again, we don't know. It can be accurate, or it could be accurate. I looked at his work product. He had worked long on it, and I think it was an accurate representation or an approximation of him at the vehicle. We can argue 1 arm, 2 arms, but I think it's an accurate representation of him at the vehicle reaching in.
Okay. Certainly, if it was 2 arms, it's an accurate representation.
Certainly.
Okay. But that's a guess. You don't know.
Only one person does.
Okay. You don't know.
Personally, no. And it's not clear on video, so.
The purpose of you having these digital creations made with Mr. Dustin was you wanted to demonstrate sight lines and sort of what it may have been possible for Mr. Harris to see, right?
We wanted to create an approximation of what he could have seen. Well, once again, we can't 100% say yes or no. What we can say is this is an approximation or a mapping of the scene of where baby Cooper died.
And you certainly would agree with me that it's an approximation which is based on your theory.
It's an approximation made upon his height, made upon his position in the vehicle.
Based on your theory.
His height, his position in the vehicle, which will lead us to make an educated guess or theory.
His height and his what?
His height and his position in the vehicle.
What other information did you provide to Mr. Dustin to assist him in creating the digital creation?
He was shown photos. He was guided by myself. He was guided by evidence on the scene, the paint markers and proximity to items or landmarks. That would be about it.
All right. Well, what about the height or weight or stature of Mr. Harris? Did you provide him information regarding that?
I just said yes.
Okay. What'd you tell him?
It's 6'2". That was obtained from his booking.
Okay. When in his report where he indicates that placement of the what he's calling a model, that being the cartoon person, placement in front of the door of the Hyundai, he indicates that all locations were verified with the assistance of you. You don't disagree with that, do you?
No.
And did you assist in the scanning the interior of the vehicle, where we heard about the two different types of scanning that was done? Did you assist with that?
I did.
What information did you provide to Mr. Dustin to help with the scanning of the interior?
That the suspect, the accused, was sitting in the driver's seat, and that he was a 6'2" male.
Right, you heard his testimony that he sat in the driver's seat and you stood outside the vehicle, and at some point in time he was placing one of the scanners, and you gave a thumbs up.
Correct.
You would agree that was just an approximation.
Correct.
You didn't use any sort of measurements, a tape measure, a ruler, something else. It was just sort of eyeballing it up.
That's correct.
Okay. At the time that the interior scan was done, had the car seat been removed?
Yes.
Who removed it?
To begin with, I believe CSI Grimstead removed it at the beginning to put into evidence. I have to check the reports, but it was removed from the vehicle after it had been measured and photographed in place.
Okay. Who put it back in?
It's myself and CSI Eric Rich.
Okay. And do you recall when it was put back in?
The day that we did the scan.
Okay. The
Or
interior
scans. I think it was twice we put it in there, if I remember correctly. But the interior scan, which you were talking about with the handheld scan, is that what you're referring to?
I'm asking now about when you put the car seat back in.
And I'm asking what time. Are you talking about with the handheld scanner?
Let me ask you this way. How many times have you taken the car seat out and put it back in?
It's been a few times.
Okay.
It's evidence. It's not being left, with the vehicle. It's put in. It's measured. We have a diagram drawn out by CSI Grimstead. And every time that car seat goes back in the vehicle, everything is measured. It's compared to the photographs to make sure that is a close approximation to where it was originally.
A close approximation.
Yes, sir.
Not exact.
As exact as we can get it.
As far as the scan of the interior, if that was that also done on July the 4th?
No.
When was that done?
I don't believe so. Scans of the interior of the vehicle were done on the 2nd, on the 12th, and on October 15th.
July 2nd,
July 2nd,
July 12th.
July 12th, and October 15th.
And of the product that we see that's been marked today and that we've all taken a look at, do you know which of those days were the scans that we're actually using?
I'd have to ask Mr. Dustin about that.
Okay. All right. Well, let's start with the second. Are you the one that put the car seat back in on the 2nd?
I don't remember if the car seat was put back in that day. I don't believe it was.
All right. So if he did a scan that day, he did it without the car seat being in there. All right. And then on July the 12th, are you the one that put the car seat back in that day?
Yeah, I did help with that. With, I believe, CSI Rich helped me on the 12th and the 15th. 15th I'm positive with. On the 12th, I'd have to go back and look.
Okay.
I believe I assisted on the 12th. But on the 15th I was there.
And then it was removed again on the 12th, and then in October you put it back in for scans to be done again.
Correct.
Okay. And it was Rich that helped you then?
I believe so.
Is your testimony that each time you put it back in, you measured exactly how the seat was fit in the car pursuant to the measurements that Grimstead took on initially?
That is correct.
The mannequin. When did you order that mannequin?
I didn't order that mannequin.
Who ordered that mannequin?
It was ordered through the district attorney's office.
Did you ask him to order it?
It had been discussed. We had gone through a few that we decided that were not close to an approximation. They look more like dolls that could be obtained from like a fire station. So the decision was made to get a more realistic, more closer approximation mannequin, model, whatever you want to call it.
Okay. So it was not your idea. It was the DA's office's idea.
It was our idea originally to have one, and the DA's office stepped up and paid for it, did the research, and purchased it for us.
Okay. Do you know how much it cost?
No clue.
And you said for a better approximation. Tell me what you mean by that.
It's an approximation or very close to the actual size of Cooper Harris.
Okay. Very close.
Very close.
How close is very close?
The measurements they took were almost exact.
And as far as almost exact, do you know where the measurements may have been off a little bit? Was it length of?
The measurements are always going to be a little bit off. Depends on who's measuring it, how tight they're pulling the tape, how the skin is moving. Mm-hmm. It was as close as they could get it.
Okay. And is that because you wanted to have a doll in the seat that was as close as possible to the actual size of Cooper Harris?
True.
All right. And why was that? What was the purpose? Why did you want that?
Because we had no pictures of Cooper in the car seat.
Okay.
Cooper had already been removed. We would not put Cooper back in the car seat to take photos of where he died.
Okay.
That is the crime scene, right there inside that car. And the doll helps us, with an approximation. Mm-hmm. And it's something that even the MEMI's office is doing more and more with child deaths. They use the mannequin, and they have the parents show us, especially with SIDS or other related type of child deaths. They use the mannequin, and they bring it in, and they have the adult caretaker, whoever was there, shows exactly how the child was when the child died.
And the purpose that you were getting it for was his physical size as he sat in the car seat.
Correct.
Okay. It had nothing to do with his face, right?
No.
Okay.
No, we have crime scene photos of his face.
Right. And in fact, you've become aware that the company the lady that makes these dolls, they're dolls made to look very, very lifelike, like the actual child, right?
That's my understanding.
Okay. So what I'm asking you is, what purpose is served by having a face that looks identical to Cooper Harris?
The purpose is served is that what the lady gave us. That's what came with whatever package they bought or whatever doll they bought, was a complete lifelike approximation of Cooper.
But as far as law enforcement and investigation, the characteristics of the face, they don't matter.
They matter. They don't matter on that doll.
They don't matter on that doll.
They matter. If the doll had no face sitting in that car seat, it would still be an accurate representation. With the face, it's more accurate. It If you compare the autopsy photo or the photo of Cooper laying on the pavement, it's very, very, very close to both scenes.
And so if the face were blank or covered, for your purposes, the measurements and the sight lines and all that, a doll with no face would serve that purpose.
Yes, sir.
Okay. The doll has eyes that are unnaturally wide open. Would you agree?
No.
Okay. Would you agree they were wide open?
They're partially open. They're not wide open.
It's your testimony that the doll's eyes are partially open.
That's my testimony.
Okay. You've seen the doll?
I have seen the doll several times. And they're not wide open.
Thank you.
Brief redirect. Defense counsel used the term eyeballing when we're talking about scanning the interior of the car. We're talking about a pretty confined space, though. Is that correct?
Yes, sir.
We're not, in other words, eyeballing where something is in a room this size. We're talking about the interior of a car, correct?
That is correct.
Was the scan taken from any seat other than the driver's seat?
Yes.
For the handheld scans?
I believe so.
Okay. For the scan that we heard testimony about, that for the iPad, that was only from one seat, though. Is that correct?
Yes, sir.
Which seat was that from?
The iPad video was shot from the driver's seat.
When you talk about approximation, we're really talking about demonstration. Do you agree?
Yes.
Okay. And counsel was asking you if you knew for certain which hand, how many hands went into the vehicle. How can we say that any hand went in the vehicle? What evidence do we have of that you could share with the court for our record?
Well, the evidence we have is that he was up against the vehicle and it appeared that the bag was thrown in. It appeared like there was some movement there.
You were asked a bunch of questions about photographs of the vehicle and of other areas. Are those 2D or 3-dimensional?
Photographs are 2D.
Because of that, are there limitations for the photographs as opposed to the 3D scan?
Yes, there are.
Which is better for showing spatial proximity of items within a scene? A 2D photograph or the 3D scan?
It would be a 3D scan.
Finally, last point I think I need to make. You were present in court when we just came back from the lunch break and queued up the Home Depot scan. Is that accurate?
Yes.
And you had a chance to compare State's Exhibit Number 1, the photograph that was tendered from the video of Home Depot. Did that demonstrate accurately, that being the scan, did it demonstrate accurately where you saw the vehicle and the defendant from the home video?
Yes.
All right, thank you.
You've actually seen the scan a couple of times, haven't you?
Yes, sir.
Okay. And you would agree, you recognize that this defendant's Exhibit 1 is an image which would have been a still or clipped from one of those scans?
I believe so.
One of those creations?
I believe so.
Okay. And as far as, again, placement of Mr. Harris in relation to the car, all of that information, all of that was based upon the information that you gave Mr. Dustin?
Correct.
Okay. Did you say that you had reviewed this report?
I don't remember reviewing it. I'm sorry. Reviewing it.
Let me just show it to you real quick. I think it's pretty close to being through here. Does that look familiar?
I remember sitting down and reading it. I may have a copy. I do not recall reviewing this stuff.
Okay.
It could be, I'm sorry. I don't recall.
Well, I'm going to consider it anyway as defense too. Don't have any objection to it. And so the court will know I've underlined a couple things in there, and I didn't bring a clean copy, so I can substitute it for you too.
You just want this to be part of the records?
Yeah, I'm just going to leave it as two.
All right.
Okay, thank you. Thank you. That's all I got.
Thank you.
Are we done with that?
Yes.
Both sides?
Yes, Judge. I think we just have a couple of other motions from the defense that do not require evidence.
Well, let's have some argument.
Yes, you are very soft-spoken sometimes.
I am very self-spoken. It was all those years as a child that my parents used to make it quiet.
I think I heard you say the word argument. Did you ask
You
this?
didn't do? You want to do that?
The defense's motion, I thought they were going to go and tell you why you need to exclude it. So,
You know, I'm here.
I'll let Mr. Ford go first.
I'm here and I'm listening, and I'm soft-spoken.
all right. Judge, just a couple of things to start with. To be clear, the purpose of this, the evidence that we have sought to tender that the defense has filed a motion to exclude is for demonstrative purposes. This is not a reenactment video showing the actual commission of a crime. This is not something showing how the criminal acts happened while the defendant was driving in the car, him turning around and looking at the child, anything like that. This is not serving that purpose. Just so Your Honor knows, the purpose which the state is looking to introduce this evidence is as demonstrative evidence to show distance and spatial proximity, to show the crime scene in a three-dimensional manner, whereas photographs and things of that nature may not capture all of that. For instance, one of the things the defense talked about when we were talking about the bringing the car down to view it at the crime or at the courthouse when we have trial. Of course, we're not going to want to get jurors in the car, things of that nature. Some of the scans and the photographs, repeated photographs, which come out as a scan as well, are depicting the different photographs of the interior of the car as they show spatial proximity and distance. So I think we've been using a lot of terms here today, and the courts on the cases that I'm going to cite, Judge, use different, nomenclature. There's terms like animation, simulation, things like that. What we have here is a three-dimensional mapping and scanning, basically akin to a three-dimensional diagram, model, chart, something like that. What this is not, which we believe we've met the burden to even show if this were some type of simulation of the actual commission of the crime, we believe we've met a burden of introducing that. This is not what this is meant to show. Just to start with, Your Honor, first of all, the state of Georgia, since we've enacted the new evidence code, has addressed recently one case involving demonstrative evidence. That was Smith versus Estate, which I have. It's a July 5th, 2016 case. I have the docket number for it. I don't have the appellate decision yet on it. It's S16A0398. This was an abusive head trauma case involving alleged shaken baby syndrome, shaken impact syndrome. In that case, the medical examiner used a baby doll in front of the jury to demonstrate how some of the injuries appeared to have been afflicted and the amount of force necessary to cause the injury. So just starting from this proposition, Judge, even in this Smith case that the Supreme Court just ruled on, that was much more of a simulation/experiment than what we have shown you here today. In that case, the defense objected and said that the use of this doll, not only just of a doll, but the use of it by the medical examiner was not supported by the evidence, as the defendant had denied shaking, and said that the probative value substantially outweighed unfair prejudice. Later, they also said there was no way to know the amount of times the child was struck, the times the child was shaken, etc. The doll in that case was approximately the same size as the victim. In this case, it was within 6 inches and within 6 pounds. The doctor said that it would help understand how the injuries were caused, and the court held that this was admissible and allowed this actual experiment or demonstration, not just to show a doll or show a map or show a diagram or a scan. They admitted this. The reasoning was the doctor had said that it would be helpful to the jury and that the doll was substantially similar. The demonstration was based on evidence in the case, the autopsy records and the medical records, and the witness was careful to qualify testimony where details were uncertain. And I can assure you, Judge, one thing the state is going to do in this case when we do introduce this is to point out, A, we're not trying to show exactly how the acts happened inside that car. It's merely to be demonstrative. But also, when you can't say that there's definitely one arm or 2 arms, we point that out. That, look, we're uncertain. And to kind of get on that point, Judge, if we'd have put 1 arm on this diagram, they'd have been complaining that there wasn't 2. So there's no way to know. It's damned if you do, damned if you don't. So we did what we did. And that is subject for cross-examination. In the Smith case, the Supreme Court talked about demonstrative evidence and talked about what that is. Charts, models, diagrams, replicas, reenactments, pictures, and devices used to aid the trier of fact. They looked at, under Georgia law now, applying the new evidence code, what the different rules are that apply to this. Well, first of all, relevance under 401, a 403 balancing, and also it's subject to the reasonable control of the court under Rule 611. In this case, they actually talked about some things and looked at, if it is an experiment or something more than we're showing here, what the standard is. They held that, citing U.S. versus Gaskell, which is an 11th Circuit 1993 case, that the court has wide discretion in admitting evidence of experiments conducted under substantially similar conditions. That's going further than we're even trying to do here, Judge. The burden is on the party that's offering to lay a proper foundation for the establishment of the similarity of circumstances and conditions, but the conditions do not need to be identical. So nearly the same in substantial particulars as to afford a fair comparison in respect to an issue which is to be tested directly. Again, Judge, they also talked about the fact that the demonstrative use of evidence in a case, one thing to look at is to see if you've done things, you're using it for dramatic effect or emotional appeal. And I'll talk about the Surge case. It's out of Pennsylvania, applying the federal rules, their rules, which are akin to the federal rules, things that you look at that may have caused emotional appeal or something that doesn't apply to just a demonstration. Say sounds were included, evocative lifelike movements, transitions between scenes to suggest a storyline, evidence of blood or other wounds when that's not necessary. Judge, injuries to the child. In this case, there were other injuries to the child. Those aren't shown. Other things, we're not showing the child moving around in the car, not showing the defendant in the car looking at the child, him turning his head in any way. So there are a number of things that could have played into that and could have been something for dramatic effect that are not the case. As you saw, Judge, those 3D scans are about as sanitized as you can get. Looking at another case, Judge, Altman versus Bobcat, that's 349 Federal Appendix 758, it's 2009. I believe that is a Third Circuit case. In that case, there was animation to show designs, superimposed hypothetical design modifications over the one at hand, basically showing in that case in a product's liability how you could eliminate risk. Similar objections in this case were had at that one. It was prejudicial, misleading, and improper. The court talked about the difference between recreating the actual crime or event and something illustrating something at a crime scene. Here, in that case, they held that the demonstrative evidence of a computer animation or a computer map, things like that, was not a recreation, and that 403 in that regard does not require a showing of substantial similarity. Your Honor, I believe we have shown substantial similarity, but we're not even required to, as this is demonstrative. Your Honor, going to Lewis versus New Prime, that's 2013 U.S. Lexus 1648593, Northern District of Georgia, 2013. That case I've included, Judge, merely to serve as an illustration that even if this was a reenactment of an event, the defense may disagree with some of the things with their theory versus our theory about why we put things in this animation. This case is in there to show that even when the defense disagrees with some fact or some portrayal in a reenactment or a computer-generated or video reenactment, that does not make it inadmissible. And kind of going in that vein, Judge, I've given you several cases that talk about the importance of both the limiting instruction, about the consideration of what purpose this demonstrative evidence is being used for, and also the purpose of the defendant and defense being able to cross-examine and point out anything that they want to. The courts have held repeatedly that these tools, specifically limiting instructions, which I've included several cases with suggested limiting instructions for this purpose specifically, negate any issue on appeal when there may be some dissimilarity or argument between what is going on. As long as the jury knows that we're not trying to show this is exactly what happened, we're merely trying to show the scene and how it appeared. Looking at some of the state cases I've included, Judge, that analyze demonstrative evidence under the federal rules, or their version of the federal rules. First of all, I'll point your attention to Colorado versus Holmes. That is 2014 Colorado District Lexus 1767, 2014 case. That's the Colorado theater shooting case. In that case, they discussed computer animation versus computer simulations. That's basically how they view it and the nomenclature they used. Basically, they held that under the federal rule type model, that an animation or something of that nature that is demonstrative in evidence is used only to illustrate a witness's testimony. And again, then delineated that versus the more higher burden of a simulation, which is a recreation or experiment based on scientific principles entered into a computer to analyze and draw conclusions. We're not showing a bullet fly through the air, through a wall, through suspected trajectories to reenact how a shooting happened or something like that, Judge. Here, this is much like they did in the Colorado shooting. They wanted to recreate a life-size model of a portion of that theater. What we're doing is the same thing through photographs and things like that, but doing it in a smaller, more succinct 3D way here in the courtroom. The next case is Clark versus Cantrell. That is 339 South Carolina 369. They addressed computer-generated demonstrative evidence under the federal rules. Similar to ours, they talked about it being relevant as one of the prongs, that it's fair and accurate as to which it relates, that this is fair and accurate, what you're seeing as to what they created, and that it is admissible under a 403 standard. And in that case, it was another one that had a limiting instruction which helped illustrate that this was being used for a proper purpose. Your Honor, going to People versus Duenas. That's 55 California 4th 1. That's a Supreme Court of California 2012 case. This involved the murder of a deputy and also discussed animation versus simulations. And what was key in that case, what was admitted, was a 3D view of the street and a 3D view of the body of the crime victim in that case. They pointed out that animation aids, while what we have here is technically and scientifically not an animation, what we call it here, I guess, is animation, it aids, while simulation is substantive evidence itself. And they held that the 3D view of the street and the rendering of the body in that case was admitted and relevant as an animation or as an aid because it was relevant to show the locations and help illustrate the state's theory. While we have pictures and photographs and things like that, Judge, we don't have the same capability of giving this spatial proximity and distance and views like that because, as we know, we're not going to be coming back here to view the crime scene, so this will assist the jury. State versus Zlan, Z-L-A-H-N, 2014, Montana 224, that's a Montana 2014 case. There were videos made by the detective to show different angles and viewpoints. It was held not to be a reenactment, but to show physical distances and vantage points. Much like the interior of the car with the scans here, Judge, as the Mr. Dustin testified, the detective testified, what these scans are just a ton of photographs taken from an angle inside the car to show the car from that angle inside. That's exactly what that is for. This, in our case, like it was in Zlan, based on witnesses and also based on people who are available for cross-examination at trial regarding these circumstances. To address a couple of the cases cited by the defense in their motion, the Pickering case, which is the main one they cited, it's a 1998 case, well before we've had the new evidence code. Pickering actually discussed a video reenactment of the crime used by the state during opening, and in that case, they held that where videotapes do not portray original facts and controversy, but represent a staged reproduction of the facts in the incident, that the extreme vividness and, I can't even say this word, so I'll spell it, verisimilitude, verisimilitude?
Verisimilitude.
Okay. Pictorial evidence is a two-edged sword. And it talks about confusing art with reality. Judge, there is no way a jury is going to confuse the 3D scale model and diagram with reality in this case. Again, Pickering and the cases they cited in their motion, I don't know what they're going to cite now, but those are inapplicable because they were actually ruled upon before we had the new evidence code. While they maybe have some insight as to how you look at a reenactment versus demonstrative aid or things like that, those aren't the standards we're going to be looking for here today. I think the main thing to talk about, Judge, the main point here, I think I've made it several times, so I'll sit down here, is that the purpose we're using this for is just to aid in testimony and to demonstrate to the jury as demonstrative evidence spatial proximity, distance, the views from different angles of the motor vehicle at play in this case. In Commonwealth versus Surge, that 2006 case I've included in the packet, it has great summaries and discussions about, I guess, the fear of using computer-generated models and things like that. And it cautions us to just chalk that up and not use it, because when it's based upon forensic and physical evidence elicited at trial, it can be a very helpful tool. It's a different mode, but not in meaning to old days when you had people chalk out outlines and things like that. It's just we have tools to actually show things better now. So we should not be prohibited from doing that when it's to help demonstrate to the jury the actual scenes and crime scenes and things of that nature.
Heard from Mr. Boring a couple of times that the purpose of this is to aid the testimony of witnesses. So the first question I've got is, exactly what witness is this going to aid? Who in the world is going to get up and testify that this is going to be an aid to them? That this recreation, this recreation is going to aid to them. What witness is that going to be exactly? Because this evidence is nothing more than created evidence. It is a creation. What we have are lots and lots and lots of photographs. You've heard testimony of it was over 100. We got photographs of all through the interior of the vehicle, the exterior of the vehicle. We've got video camera depicting the exterior of the vehicle, the interior of the vehicle. Scenes depicted in the creation involving the cartoon figure standing in the door front. We've actually got surveillance video. That's the highest and best evidence. That's actual evidence. What this is something that they've created based on their theory. And I don't think anything could be more stark than very simply, well, we don't know if he had one arm or two arms in, but it's depicted as two. Why? Because that's their theory. That's the state's theory. Well, what's the concern? What's the worry here? Well, the concern is that this kind of evidence, the court can close its eyes right now and see that creation. Any of us can. If we closed our eyes, we can see that flyover like a helicopter coming in, and there's that red, we see that car seat. It doesn't matter from what angle it is, how high it is, how far away it is. It creates a mental image. And that's the danger of this kind of evidence in front of a jury. It's creating a mental image out of nothing. No, not just nothing. Out of stuff that doesn't exist, such as a car with no top on it, such as a car with no windows, such as a car with no back to it. The purpose of this evidence, this creation, is so that the juries always, when they think back in that jury room, they're going to see it. And in their mind, they're going to think, anybody, we had to have been able to see this car seat from anywhere. Gosh, we could see it. I could see it. And that's the reason why they want to use it. That's what it's for. It's absolutely misleading. It is in no way accurate whatsoever. I think the record is as crystal clear as it can be that it is clearly not accurate. What you've seen is not accurate. We don't have any, there's not going to be any evidence in this trial that Mr. Harris came in on a helicopter and was looking down on the vehicle. There's just not, from any angle whatsoever. There's not going to be any evidence before this court that he ever walked up to a vehicle that didn't have a top on it or that didn't have windows. It's misleading. I'm going to go through a couple of cases real quick, and Judge, I'm not going to just read the motion. We put a lot of information in the written motion. I'm going to rely on that without just reading back through it. But I do want to highlight just a few cases real quick, going all the way back to 1973, Island, E-I-L-A-N-D versus the state at 203 Southeastern 2nd, 619. Photographic evidence creation here, and I'm just going to read from the case. However, photographs, and especially movies which are posed, which are substantially different from the facts in the case, and which, because of the differences, might well be prejudicial and misleading to the jury, should not be used. Well, this case may be 40 years old, but the principle is exactly the same. This creation is posed, and it's posed in the likeness that the state suggests. It is substantially different from reality. It is substantially different than the actual scene, and from the photographs, and from the video. Okay, this should not be used. And this is especially true when the situation or event sought to be depicted as simple, the testimony adequate, and the picture adds nothing except visual image to the mental image already produced. A motion picture of the artificial recreation of an event may unduly accentuate certain phases of the happening. And because of the forceful impression made upon the minds of the jurors by this kind of evidence, it should be received with caution. Ultimately, in this case, where the ultimate question is not whether the jury believed defendant's statement that he did or did not know about cocaine, this contrived pictorial representation tended to become an extra witness against the defendant, and in that manner which differed from reality in substantial particulars, and it was reversible error. Mr. Boring went over the Pickering case. That is it has got some good language, which certainly encourages the court to take a look at. In that case, the trial court approved the state's use of a video reenactment of the crime as demonstrative evidence in opening statement or at the beginning of the trial, but specifically prohibited the tape from being considered as evidence or being made available to the jury during deliberations. Certain materials may be used as tools to illustrate testimony without being admitted as demonstrative evidence, but not where the illustrative material contains erroneous or prejudicial matter unauthenticated by the testimony which it purports to illustrate. When I asked the detective, well, we see in the video, we see in the animation, and we see in this photo 2 arms in the car. Where'd that come from? That's a guess. I don't know. It's possible. That is unauthenticated. So we're showing them a creation of something that is unauthenticated. Posed movies, which are substantially different from the facts of a case. And that's really all it is. This is just a posed movie. It's an animation, but it's a posed movie. In which because of the differences might be prejudicial and misleading to a jury, should not be used at trial. The party seeking to use it must show that it is a fair and accurate representation of the events sought to be depicted. I don't know how much more clear it can be that it is in no way accurate and doesn't demonstrate reality. The court cites McCormick on evidence, where videotapes do not portray original facts in controversy, but rather represent one party's staged reproduction of those facts, which is all this is. It's one party's. It's the state's version. The extreme vividness and verisimilitude of pictorial evidence is truly a two-edged sword. For not only is the danger that the jury may confuse art with reality particularly great, but the impressions generated by the evidence may prove particularly difficult to limit, or if the film is subsequently deemed inadmissible, to expunge by judicial instruction. The court goes on to cite Island, which I quoted earlier, and then says this: furthermore, videotape depicts all critical facts as they will be contended for by the state. Therefore, the reenactment, whether admitted into evidence or used for illustrative purposes only, would have the effect of preconditioning the minds of the jurors to accept the state's theory. Because it appears under the circumstances the pictorial representation would tend to become an extra witness against Pickering, we find the trial court erred in approving the state's use of the reenactment videotape. Here, we don't just have oral testimony. It's not just oral testimony of coming from a witness. We've actually got video. There's actually video from the Home Depot parking lot. We don't need it recreated as in the state's image, under the state's theory. Lastly, I want the court to take a look at Chance versus the state, 291 Georgia 241. It's a 2012 decision, Georgia Supreme Court. Appellant contends that the trial court erroneously granted a motion in limine made by the state to exclude certain demonstrative evidence. Appellant's proffer consisted of a series of photographs showing various possible reenactments of the homicide based on evidence indicating that the victim's driver's side door was open because its window could not easily be and was not lowered. The use of a reenactment is a matter for the trial court's discretion, and the party seeking to use it must show that it is a fair and accurate representation of the event sought to be depicted. But in this case, the trial court properly found that the proffer was speculative and assumed facts not in evidence. We've heard lots of facts that are not going to be in evidence. We've seen with our own eyes on this creation lots of facts that are not going to be in evidence. Photographs would have shown something very different if the victim's vehicle was moved either a little farther away or forward a little. How significant is that? If the difference in a vehicle a couple of feet one way or a couple of feet another way, the court's saying that makes a difference. Well, what about the person sitting in the car? What about where the angle of where they're holding this scanner? If it's moved even a little distance, the court realized, hey, that makes a difference. Furthermore, the photographic reenactments depict all critical facts as they would be contended for by the defense. In this case, it's a creation of the state based on their theory, based on what they say happened, not based on reality. The party seeking to use the reenactment does not show that the oral testimony would be inadequate to explain the fairly simple events depicted in the reenactments. Here, not just oral testimony, we've got photographs, video, inside the car, outside the car. We've got surveillance videos from the Home Depot parking lot. Video recording of the vehicle. We've got a lot. Because the trial court correctly determined that an adequate foundation for admission of the photographic reenactments had not been established, there exists no ground for reversal. In a nutshell, Judge, it's highly prejudicial, to say the very least, and I won't go through a full-blown 403 analysis with the court, but we have certainly pled that in paragraph 21. The probative value of this misleading and inaccurate animation, this cartoon, is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, or consideration of undue delay, waste of time, needless presentation of cumulative evidence. It is misleading of the highest sort, of the very highest sort. And I ask this court to exclude this animation creation from the trial of the case.
Well, I think it's worthy of reflection and ask for proposed orders to be submitted in a timely manner. So with this involved.
Sure.
I'll take it under advisement. All right. What else is there?
Judge, I believe the defense has 3 further motions. One of them, defendant's motion 23, I think we have an agreement on this. We don't really need to take it up right now. It is something where we at least have some common ground of what we think may be redacted, and I think it's something that as we go through trial and things come up that we can handle it as we go, and I don't think we need to argue anything right now. Is that correct, Mr. Kilgore?
23, that's fair. I think that's a fair statement, Judge. That's something that we're going to work together on, and if there's a problem, I think we will just bring it to your attention at the time.
Do you have 2 other motions, Mr. Cummings?
I do.
Can you proceed?
I can.
Can you tell me what numbers they are?
I can. Number 22.
Yep.
You've already heard the testimony. I think that both of us wanted to present on that. Do you have a copy of our motion, Judge?
I haven't brought it in.
Well, the reason why I'm asking is we have attached a photograph of the piece of evidence we are asking to be excluded.
We'll send it up and I'll look at it.
Okay.
You didn't want to be put on the file because
you heard some testimony about a mannequin that the district attorney's office purchased for trial in this case. Thank you. And, of course, the testimony you heard, as you can see from the photograph, is that the mannequin is fashioned in the image of Cooper Harris, having the same, not just body size according to the state, but clearly the same facial features. I mean, the doll looks like Cooper Harris. And the eyes on this doll are as wide open as you can possibly get. There's no way around it. They just are. And our position is that what it does, it again creates a mental image in the mind of the jury. That Cooper Harris was wide awake when he was sitting in his car seat when he was accidentally forgotten. There's no evidence of that, but that's the image that the state wants to leave with the jury here. And in paragraph 6, we point out we don't expect that fact can or will be established through evidence properly admitted at trial. It's going to be a suggestion. But again, the concern is that by showing this particular image of this doll, this mannequin, with eyes wide open, it creates a visual that the jury cannot unsee. And that's the reason why the district attorney's office wanted to do this, and they wanted to get a doll that would leave a certain mental image. The facial expression and fixed gaze, it is not relevant or probative to any issue. And if you remember the testimony of Detective Stoddard, face doesn't matter. Detective Stoddard admitted. What we're looking at really are the dimensions of the child, because what we're concerned about is the having as close as possible to the body of the child in the car seat. Facial expressions don't matter. So, our position is under 403. This is extremely prejudicial, and I think it creates an unfair and improper mental image, or would create an improper mental image in the mind of the jury. So what we're asking the court to do is order that the state essentially redact the face from these images and from the doll itself. It's just it serves no evidentiary purpose, none whatsoever. And what the court's going to find out when comparing this photograph to the actual photographs of Cooper Harris, the child's eyes were not stark wide open as is portrayed in this photograph. So that's our motion.
Your Honor, if we had a faceless doll up there, we'd be having an argument that it wasn't accurate enough. And this was not just the doll or mannequin recreated just to try to influence the jury or in any way insinuate that the child was awake at some other part of the day. This was recreated because the child's eyes were open when he was pulled out of the car. This mannequin was made from the photographs at the crime scene with the child laying dead there on the pavement. We have photographs of that. That is where the doll was created from, to show as close in time as to what this child looked like when it was last in that car seat. So there is no mental image of trying to create something that happened earlier in the day. This is created to appear as exactly as the child did, as close as we could get in the photographs from the crime scene. So, Your Honor, we would ask you to deny the defense motion.
Judge, I want to make sure that I'm clear on what I'm asking for here. That not just in photographs that have been taken of this doll, but of the doll itself. All I'm asking for is that the face be covered or removed. I'm asking that the doll be done away with, just the facial expression.
I'm going to deny that motion. What is your next motion?
There was, we had a motion number 25, Judge. We had a prior motions hearing. I believe it was paragraph 3. It was October the 12th, 2015. The state elicited testimony during the hearing. This was actually the demurrer. And the term grooming came up. The term grooming, it was suggested by Detective Stoddard. The state further elicited testimony that grooming involved being a sexual predator an abuser or a pedophile. I don't believe that the suggestion of grooming or those related terms are relevant or probative to any issue that's going to be before the court in this case. And so we would ask the court to exclude that, any of that type of suggestion or testimony under 244403, that's well, it's not accurate, it's not relevant, it's obviously highly prejudicial. Sorry. Yeah, and it's opinion. It is opinion, and it is bad character testimony.
Your Honor, I would say that we will instruct our witnesses not to use the term sexual predator, abuser, or pedophile. However, in regard to proving the criminal attempt charge and other acts that have occurred with people who are children, the term grooming was used. I'll turn Your Honor to Goddard versus the State, 2014 Georgia Appeals, Lexus 835. It's a 2014 case addressing this issue under the new evidence code. Testimony by the detective there, who, as we would lay the foundation here with a detective who has investigated crimes against children, which in the state of Georgia is under 18, and for the purposes of the charge in this case, is a child under 18. Talking about grooming a child, basically that being to desensitize sexual activity and establish a sexual relationship with the child. The court held that was not something within the canon of the average juror. Basically held that it was a filling out process, something that would allow expert testimony from a detective regarding grooming. In this case, I'm sure the defense will attempt to mitigate, as they have through prior motions, their client's action with underage girls because they were consenting. And so, Judge, I believe this testimony would go toward the defendant's actions in this case to get these girls, or attempt to get these girls, to provide pictures to him.
Judge, if you're inclined to allow the state to get in, and we're not dealing with a child, dealing with a minor.
And it's sexual exploitation of children is the statute. And children under that statute is less than 18 years of age.
I understand what statute, but he said that we were dealing with a child.
A child is a singular children.
If the court is inclined to allow this type of character testimony from a detective, we have not received any notice that we've got anybody from Safe Path or CHO or wherever coming to give this sort of testimony. But if the court's inclined to allow this kind of testimony from a detective, I'm going to ask the court to direct the state to give us some sort of report outlining and detailing exactly the basis for that kind of testimony. But we object to it.
I'm not inclined to allow it or disallow it. I'm inclined to listen to the evidence and hear the objections at trial and rule on it.
Judge,
that speaks to that. Yes, sir. I'm sorry.
I apologize. You took a break, and you can tell by my voice I'm fading fast. So
I guess I take you out a little bit. Sorry.
Judge, I did show one other motion. I don't know if we need to take anything up about that today. Defense's motion for individual sequestered voir dire jurors. I think that was filed before the last time we had jury selection. So I don't know if that's moved at this point before we get out of Brunswick to have to deal with that.
Yeah, I think that the parties and the court worked real well together before to kind of come up with a game plan on how to do voir dire. And it's not something that we have to take up in the form of a motion at this time. So if the court would rather us recess and just talk about that at a later date, I'm fine with that.
I think that makes good sense. We did work well together. When do y'all want to do that? You want to do that on Friday before jury selection starts? That'll be the 7th, 9th, September 9th.
You talking about
in Brunswick?
To do it in Brunswick? I don't know what time we'll be getting down there on Friday. Because I think we all have court that day, so we'll probably be in court and then drive down after court. I don't think this is going to take.
Like a large
I don't think this is going to take but about maybe 20 minutes. So if the court wants to see if there's one afternoon we can come in, I don't think it's
Want to
going
do it now?
That's fine with me.
It's fine with me, Judge.
That's fine.
Let's change chambers.
Good.
Is there anything else?
Nothing from the state, Judge.
I just need proposed orders of the one matter that I did that in Boston. Anything else? I think you'll need to do orders.
Yes, Your Honor.
All right, we're in recess. Come back to me.
Give us 15 minutes. We'll leave that there. We'll leave it at the exit desk. Either the exit desk or the first desk.
On domestic at 9:30. There might be waivers that could show up at 9. I'll tell them
It'll probably get